joining us. We'll get started in just a few minutes. We'll give everybody a little bit of time to get in and get settled, and then we'll get started with the webinar. Good morning. Thanks for joining us for our annual employment law webinar. We're going to get started here in just a few minutes. We're going to give everybody a little bit of time to get in, get settled, get their coffee, whatever it is that they need, and then we'll get started. Thank you.
So, anybody seen Jeff? Hey guys.
Jeff?
Yeah.
What are you doing?
I'm here for the breakfast. My wife made sourdough waffles, got some clementines for my vitamin C, and I'm ready to learn. But Jeff, you're wearing your hat backwards. You got a Bill Belichick sweatshirt going on there. What's going on? This is my University of Arizona sweatshirt. This is where I went to law school. But we're presenting. You're starting the presentation. I'm starting. Let me go get changed. I'll be right back.
Well, looks like we're off to a waffly good start.
Hey guys, let's try this again. Good morning. My name's Jeff Worley, and it's a pleasure to be with you all this morning for Gibble, Crable, and Hess's annual employment law presentation. Joining me today is attorneys Lindsay O'Neill and Ian Brinkman, and Allison Fund, our assistant office administrator, is also assisting with the presentation today. We're all getting kind of used to these virtual presentations. You and I both know that it's a little bit hard to replicate that in-person experience, but we're going to do our best to make this as interactive as possible. So if you have any questions or comments, please send those over to Allison in the chat. And we're going to open this up for questions at the end. But feel free to jump in at any point. You don't have to wait to the end. Let us know what you're thinking. Jump in with your questions. You might want to think about putting this on an active speaker mode because as I'm looking at my screen, I'm seeing a number of blank boxes there. It's up to you however you want to view this. We did send out a handout yesterday. You should have received that. That's going to kind of give you a little bit of an overview of what we're talking about today. And my malpractice carrier is always happy when I tell you that this seminar is going to provide a general overview of legal topics, but it does not constitute legal advice. Each situation is going to be different, and so for your specific situation, you should contact an attorney. So let's jump in with some good news first. In 2019, we saw the fewest number of EEOC charges filed in over 20 years. We are living through some very divisive times, and yet in 2019, there were only 72,675 charges filed. Compare that to 2018, when there were over 76,000 charges filed. In 2016, there were over 91,000. And in 2010, 2011, and 2012, there were over 99,000 charges filed. So we have seen almost about a 25,000 number of charges reduction. We're continuing to see those charges go down, and that's great. Of course, those numbers are not reflective of 2020. We don't know what those numbers are going to look like for this year. Anecdotally, I haven't seen a lot of charges being filed this year. I don't know. Maybe people have other things going on, like how to live, how to work during the middle of a global pandemic. We're not going to spend a lot of time this morning talking about specific COVID-related regulations. The stimulus passed by the Congress and the various acts. We spent a lot of time over the last couple of months, and we have a lot of resources devoted to the FFCRA, the CARES Act, PPP loans, CDC guidance for operating your business during this time, COVID-related unemployment guidance. We've covered those in considerable detail, and I'm sure you probably already have your fill of those topics as well. If you have specific questions, bring them up at the end of the presentation here, and we'll see if we can answer them. If you're sitting there and asking yourself, what in the world is the FFCRA? We might need a longer chat at the end of this, after this presentation's over. But there's a lot to consider as you're operating your business during this time. How many of you have remote employees? You got a remote workforce, and some of you have all hands on deck because you've never been busier than you are right now. If you would have told me in February that the majority of my paralegals and the attorneys from my office would be working remotely for 8 months and counting, I would say there's no way that can work. But, surprise, it works. Our team has really stepped up, and they've met these challenges, and we've been able to operate, on a remote basis with limited office hours. And I miss my coworkers. I miss that water cooler talk and seeing people in the office. But I can tell you, I'm kind of getting used to this remote working, and I may never go back to the office full time. So right now, working remotely. The one thing I think that's important to kind of keep in mind as we've entered into a new normal is, keeping up with your expectations of your employees. There was a time early on in the pandemic when we, simply did not know what to expect. Everyone was unsure. Do you remember what it was like back in March? Anybody think back that far? We had no idea what was going on. And I'd say by now, we do know to expect this, that the state of what's going on now isn't going to go away anytime soon. And so now is time to kind of reassess what are your expectations and clarify those with your employees. Let's start with something simple. Dress code. I'm not going to lie to you guys. Most mornings, my routine has been I get up, take a shower, shave, and then put on a pair of clean sweatpants. When I have, something to do, I dress up. But sweatpants are awesome. But, you need to have that clarified with your employees as to, if you're client facing or you're interacting with the board or donors, what are those expectations? The president judge of Lancaster County Court System recently sent out an email to all attorneys reminding them that when you are in front of the court, whether it's virtually or not, you need to adhere to courtroom decorum, i.e., you better have a suit and tie on. And I know that the president judge is a fairly busy guy, so he's not just sending out an email to state the obvious. There were attorneys who were showing up to hearings in, I guess, their sweatpants and sweatshirts. I don't know. But, it's important, he clarified those expectations and said, hey, this is unacceptable, and the same for you. If we're looking at your office space and you have folks in your office, things have gotten a little bit more casual maybe. And if that's okay with you, that's fine. Then you might need to send out a memo reminding people, don't get too used to this. Right now it's okay, but when we have clients back in the office, we're going back to business casual. And if you look around and you want people to adhere to the same dress code that you've had, well, you can do that too. But it is a matter of clarifying those expectations because, certainly, that was one of the first things to go was people getting dressed up. And if that's an important part of what we do, clarify that expectation. Masks, they're kind of a big deal right now. And, I don't like wearing one, but I'm not quite sure how they became a political issue. But, just as you can require your employees to wear those ugly teal shirts, the polo shirts with your logo on the, you can require your employees to wear masks. Again, setting forth those expectations of where, when employees need to wear masks. That's all part of setting out in this new normal of here is what you are expected to do. What about productivity and performance? There was a moment early on when some of you were not sure what was going to happen with your business. As a small business owner myself, I was concerned about keeping the lights on. Employees were sent home. We were furloughed. We didn't know what to do. Maybe some of you were trying to apply for a waiver to reopen. Likely you were not that productive in March and April, unless you happen to be an essential service, in which case you were super busy. And, big shout out to those healthcare workers and the folks who are taking care of people during this time. But, again, we've reached this new normal for the moment. And I have a pretty good idea of what my week is going to look like. And I think, for most of you, you have a pretty good idea of what your next week is going to look like. And so what are those expectations for that week when it comes to productivity and performance? Employees who are working remotely should have a setup that works for them. And employees who are in the office or out on the field should know how to navigate these new protocols. And this is, how we're going to be working for some time. And so if you have an employee that's not meeting your expectations, now's the time to address it because it's not going to get better on its own. And whether that's, the timing of responses to emails or the number of errors in a report, showing up to work late, not finishing a job as required, whatever those issues are, have the conversation because, you need to determine, is this part of a pre-pandemic situation in which they have never been meeting expectations? Okay, now's the time to start having those difficult conversations. Or is it a post-pandemic sort of situation and maybe somebody's working from home? Do they need something? Do they need another monitor? Do they need some earbuds that cancel noise? What is it that we can do for you to help you do a better job? to meet our expectations. And I get it. You know, I understand that there are some employees that, you know, you can't help them. You know, I've talked to you guys. I've had those conversations with you. So I know that that's also, you know, a reality here. But, you know, having those conversations and then going through that process of looking at, you know, what is the performance like? You know, there's a lot of ways you can monitor performance from a computer end. If you have somebody who's, you know, on the computer, you can monitor the number of keystrokes, number of words per minute. There are specific programs that will allow you to do so. You know, I don't generally recommend this because you can see whether an employee has been productive or not by the output of work. Keystrokes don't measure quality of work. You know, each situation is going to be unique, but looking to what the employee's been doing and how they're doing it now, and what are your expectations. And of course, during that process, documentation is going to be key. That document should set out your expectations and what needs to improve and what needs to change. And a lot of times, you know, I recommend that you're setting forth the time frame in which it needs to happen. If it's somebody who's late to work, it's saying, you know, you can't be late to work again. If it's somebody perhaps in your sales force, it may be saying, we need to see an uptick in sales in the next 3 months. And the document, you know, needs to let the employee know what's going to happen if they don't make the changes. And the hope is you see the changes that are, you know, required. And if you don't, you now have the documentation to back up that decision. And if it, you know, really goes south, you know, you have those documents to present in court, you know, during the discovery process, during your deposition, whatever the case may be, to show we did everything we could do. We had the conversations. What are you doing about your employees' use of the internet? You know, this is, you know, primarily related to remote workers, but employees, you know, typically don't work straight through 9 to 5. You know, we all know they take time to sit by the water cooler and catch up on the football game last night, or hear Janice talk about her grandkids, or whatever the case may be. Employees, you know, who are working remotely aren't having that interaction. And so you may see them checking in on social media more often, or checking out to do other things. You can have a policy that prohibits employees from utilizing social media or other, you know, uses on your network if they're using a VPN to come into your network. And there are security reasons why you may want that to be in place, as well as productivity reasons. You know, again, you can't tell whether somebody is, you know, what they're doing on their phone if they're working remotely, or whether they're just sitting at their desk staring out into space. And again, that comes back to measuring their performance and measuring their productivity and having those check-ins. And I think that that's another key component to this, is if you have employees who are working remotely, that you're taking that time to check in with them. And then that you're looking at, you know, if somebody's struggling through this process, you know, do you have an EAP program, an employee assistance program? And if you don't, that may be something to consider. You know, is there, you know, getting them into a therapy program for a couple sessions to work through, you know, whether it's anxiety or whether it's just, you know, I don't know how to do this. I don't know how to self-motivate myself. There are those tools there that you can provide to your employees. What about your expectations as to security? You know, because again, if you have remote workers, there's a good chance they're logging into your system through that VPN network, and they're sending a lot of emails. And now is really the time to make sure that your security protocols are in place. You know, and Ian, you were recently at a seminar on cybersecurity, is that right?
Yeah, it was. Thanks, Jeff. And I want to drill down a little bit on some of what Jeff spoke about, particularly with regard to cybersecurity and working from home. So in general, the instances of cyber attacks or attempts to access a company's information and personal private data are increasing significantly over the past 5 years. not only anecdotally in our own lives, but also in our professional lives and in the trade groups that we're a part of. It's just a constant topic of conversation. And like Jeff said, I attended a day-long seminar on the subject. So it's that important to us. And working from home has only increased our vulnerabilities. Like Jeff said, so much of what's going on is new. And when we have newness, we're not as on guard as we normally are. When we're out of our normal workspace, foreign emails or phishing attempts might seem kind of normal because we're dealing with new people and new emails and new systems and new ways of communications. And then also particularly the last 2 months of the year, the holidays, and the first 2 months of the year around tax season are particular times of vulnerability, especially on the employer side, because on employee side, because the employees are engaging and interacting with employers about tax issues, time off, pay, and things like that. And it's a perfect opportunity for criminals to sneak an email in there with a couple of differences in the tag, and then have somebody click on a ransomware or something like that. The United States is the #1 recipient of ransomware attacks. So, the US is particularly vulnerable, and so are small and medium-sized businesses because they're the perfect amalgam of having enough assets where it's worth going after, but maybe not enough capacity to deal with those attacks before or after they occur. So, like Jeff said, it's time to plan, and it's really actually time to plan this time. We talk a lot about planning to plan, but it's really time to sit down and discuss with your IT departments and your managers about what the expectations are and what it will take to have a comprehensive cybersecurity policy. So when working from home, I think there needs to be 2 policies. One, Jeff already kind of touched on, and that's who gets to work from home. When do they get to work from home? What does it look like? What does the process of seeking out that permission entail? But then within that policy, there needs to be a specific telework cyber policy. So this is, again, where you're going to sit down with your IT professionals and your managers and to see what the needs are and what your capacities are. You're going to want to just lay out, at first, you're going to want to lay out the basics. So who can telework? How do they telework? When can they telework? Who do they ask for this permission? Is it more of an employer convenience type of policy? Or is it if you meet the metrics laid out by the employer, any employee can take time off or can telework from home? But then you're going to want to focus in on the actual technology and the working from home and connecting to the company's network from home. So the specific electronic and technology aspects of the policy. So just start again with the basics. What type of devices are allowed to be used? When are they allowed to be used? What can they connect to? Maybe you have a certain brand or company you like to use, or maybe your IT professionals think that certain devices are more secure than others. So make sure that that's clear. And then also, what type of tech specifications must the technology have? I know that certain VPNs and things can only support certain devices and hardware and software. And again, to make sure that you hit the ground running and are efficient in this, having all that laid out ahead of time will help ramp up as quickly as possible. And then getting into actual security. So do you have a 2-step verification process? Are you using a VPN? And you'll hear this from me a couple of times, both from the policy side, is that there's not a one-size-fits-all. You're someone that's answering phone calls or doing, minor office work away from the office is going to require different security measures than maybe your payroll or HR professionals because of the sensitive data they're dealing with. So one size fits all won't work. Look at the actual work and the data that the people who are working remotely are interacting with. And then similar to what Jeff said about working in the office, what type of behavioral controls or expectations does the employer have from working from home? What type of hardware, software, and other technology can be used, and when can it be used? Working from home removes a lot of the social, natural social controls working in the office has. Not a lot of your employees are showing up at 6 o'clock in the morning to get in, But when they're at home, they can get on the VPN arguably whenever they want. Does the employer not want the VPN to be accessed during certain hours? Is the laptop that the employee was given by the employer, is that just for 9 to 5 work and nothing else? Or is it more something that is meant to facilitate working from home and can be used on the weekends to prepare taxes or write a letter? And then just all the rules surrounding that. You know, what type of websites are appropriate. Think about all the ways that the in-office setting provides guide rails and rules and responsibilities naturally, and then write them in a policy from working from home. Very similar to the water cooler talk. What type of stuff and interaction is not available from working from home, and then how can you replicate that? And then there's the more security, both the hard and soft security. So what type of firewalls, encryption might you need? Again, we're trying to replicate the security that you would have in the office at home. But also then we have to worry about hard security. This might be the first time that laptops, physical files, and thumb drives are leaving the physical office space and traveling away to other people's houses. You know, what are the rules for locking things in vehicles, storing things away when they're not in use? We think of working from home as something where we are actually at home, but telework and remote work implicate, you know, working in a library or going to Starbucks. Should people be able to connect to the Wi-Fi there? You know, what type of security measures should they have? And then finally, the policy should address access restrictions. So early on, a lot of remote work was far-flung and done out of necessity to keep things as normal as possible. But now that we have 7 months under our belt, who is given broader access out of convenience, and that they really shouldn't have that access now? This is important for protecting trade secrets, and it should also apply to your contractors that are coming in on a one-time basis. You know, is there a time limit when access to certain files or servers should be cut off? Who is monitoring that type of thing? While you're doing this, one of the best things to do is, again, involve your IT professionals and have tabletop exercises. Go through hypotheticals. Who is going to likely ask to work from home? What type of data are they going to use, and how do we protect that data? What happens if someone asks something that we haven't planned for? You know, just work through those types of things, write them down on a list, and then develop them into policies. Using examples in addition to hard and fast rules is another great thing to put in a policy. So
your cyber criminals have always been working from home.
Yes, exactly.
And they haven't stopped working.
Yep. And that's very important. Transition to my next point is that, you know, we're combating against cyber criminals. They're smart. You know, they've been doing this for a long time. They're anticipating the changes that have happened that are beneficial to them. But they also know that a lot of times we have these great plans, but we never train anybody on them. We have our C-suite executives know the cybersecurity or teleworking plans inside and out, and then the people that actually have to implement them or use them aren't really trained on them. Human error and phishing attacks are one of the easiest and most common ways cyber criminals can get into a company's data. So, you know, train your employees, use metrics and things to discover where they have read the materials, how thoroughly they know them, and don't just focus on the people that that have the most sensitive information, but, you know, from top down, everyone needs trained. So again, I know that not everyone has, you know, all the resources that they might like to develop these plans, but you really should think about splitting your time and effort between planning and then training on the plan, because again, the plan is only as good as the people trained on it. So I just have a couple of quick other reminders of things that are really coming across our radar lately. So like Jeff said, you know, we can plan and we can train and do everything, but, you know, cyber criminals, you know, they're smart, they've been doing this a long time, and they're going to adapt to our responses to them. So in the unfortunate event that there is actually a breach, we need to go through this whole planning process, but from the standpoint of there's been a breach, how do we respond to it? So again, it's very important that we involve our IT professionals, and to the extent that you do have the resources, there's lots of good third-party information and service providers out there that will help you develop these types of plans. Because planning and preventing these types of attacks is so difficult at times, insurance is a really big and important factor to fill in those little pieces where the plan might not be foolproof. But it's also important to know that your general liability or your errors and omissions insurance is likely not going to cover a data breach, particularly certain types of data breaches. So you're going to want to review your current policies, find the holes, and then seek out riders or completely separate cyber liability insurance policies that are specific to the types of data and the types of work that you're doing. Finally, while we can sit here and say that it's best practice to do these things, really where the rubber hits the road is anticipating the future, and that, you know, not only is it best practice, but a lot of these obligations are going to become legal requirements in the future. We have the data protection laws coming out of California and the European Union, and while a lot of you guys might not have customers coming from those areas, right now Maryland and New York are both working on similar corresponding laws. And it's much more likely that East Coast companies will have to start dealing with similar regulations as in California and Europe because of other closer states enacting those laws. And also we see a trend moving that it's not just about customer data, but it's also about employee data. So you have a responsibility to protect customer data, but also employee data. And that's a new case that's come out of Pennsylvania. So, you know, it's not just about, well, I don't take credit cards, so I'm fine. You know, just do a hard self-assessment on the data that you have and how you can protect it, and the new ways that working from home change those aspects.
Thanks, Ian. You guys hear we have an election coming up next week? Talking about expectations here, what are some of the expectations that you have in the workplace as to you know, what employees can discuss? How are we allowing employees to engage in political speech in the workplace? Let me ask you guys this, and you've probably heard me say this before. Do employees have a Second Amendment right to bring a gun into your workplace? No, of course not. Ian, do employees have a First Amendment right to freedom of speech in the workplace?
No, they do not, unless it's a public employer. So it's a good point, and it's something that's been a hot button issue lately. And it's something really, not only are you going to have to develop a policy and a plan, which you'll hear a lot from me throughout this presentation, but you're also probably going to have to reinforce these expectations, because there's a lot of confusion about where the First Amendment applies and where it doesn't apply. So not only will you have to make the policy, but you're likely going to have to remind your employees pretty frequently that this is an employer policy. So I think just like the work from home, and Jeff elaborated, that there's a whole host of controls and measures that an employer can develop to restrict or curtail political speech in the workplace. Now, you know, the first thing will be is to make sure that you have, you know, an idea of what you want. Jeff, can you talk just a little bit about, you know, the type of culture that an employer might want to have?
Yeah, I mean, because we're not suggesting that you necessarily, you know, curtail speech if you're comfortable with this, you know. But I think what we're just seeing at the moment is, you know, people, just as you would, you know, say to two guys, you know, I like the Eagles and somebody else likes the Cowboys, and we're back and forth all the time, but it gets really heated. You know, some people take sports really seriously. You might pull them aside and be like, we're done talking about sports. And same way with politics. And so the point being here is, you know, that you can limit that to the extent that it becomes disruptive or you know, or a distraction.
Yeah, and that's a good point, Jeff, is that even though the employer has a lot of leeway in what they can curtail, after they've decided, you know, what kind of culture they want to develop, what type of leeway employees have on the spectrum of talking about politics, you know, at work, it's going to be important once you decide, the culture that you would like to create to put it down in a policy, to have it written out and have it clearly explained to employees, particularly in this area where the political speech in the workplace policies might not be very familiar to a lot of employees. There might have been a lot of ad hoc enforcement up until this point. So again, it'll be really important to have a very clear expectations and lay those out. And employers have a lot of leeway in what they can restrict, but there still are small portions of workplace political speech that might run into areas where the employee has the ability to participate in that type of speech. Jeff, do you have some insight on that?
Well, I mean, first of all, you have, your NLR, National Labor Relations Act provides that an employee can concertedly talk with other employees about the terms and conditions of the workplace. And that's, a very enforced statute. You have your right to bring up safety concerns through OSHA. So an employee absolutely has a right to bring up any safety concerns they have. And then an employee has a right to raise complaints regarding discrimination or harassment. So you have those as definitive rights to free speech. And we could get into nuances of, well, does an employee have a right to wear Black Lives Matter shirt or a Blue Lives Matter shirt or whatever the case may be? And it's going to be somewhat nuanced for your specific situation. It's going to be nuanced as to what you've allowing other employees to do as well. And certainly, as we get, into these nuances, it's kind of difficult to sort of throw out hypotheticals. But, I think it's really looking at what culture you want to create and then, deciding, and it may not be necessarily, I think generally, we're going to say a written policy is going to be best, but it may sometimes be an email that goes around and says, hey, folks, we're really going to focus on work here and we're going to kind of drop some of the banter we've been having going on here, depending on, what's needed for this situation.
Yeah, and I think there's one other area that employers should look out for if they adopt these policies, and that's some Pennsylvania courts have said that a single violation of a political speech in the workplace policy that doesn't disrupt the day-to-day operations of the company, and the business would like to fire that employee upon the first violation, that there could be some extra protections there. So this is one of those portions of a policy that you should really interact with your attorney. Maybe again, plan and describe what type of culture you would like to develop, then have the attorney really put that to pen and page and give it life. And then also the first few times that you're implementing the policy, unless it's clearly egregious disruption of the workplace, you should seek out your employer for some advice on how to deal with the first couple of disciplinary actions.
We were talking about the National Labor Relations Act, and the NLRB is the board that enforces the act. And they recently clarified this year in a ruling that employers can discipline an employee for abusive or offensive statements, even when it's done in the context of protected speech. So again, as I said with the NLRA, employees can engage in concerted discussions about the terms and conditions of the workplace. So it's protected to say, I feel as though my boss is wrong for making me work overtime on a Friday. That speech is protected. It's dealing with the terms and conditions of the workplace. But what the NLRB said is you can't couch abusive and hostile and offensive language in a protected speech. And so, you can't, an employee can be disciplined for saying, my boss is a big jerk, et cetera, et cetera, et cetera. I'd like to punch him in the head because he made me work overtime on Friday. Absolutely at that point, simply because the employee was discussing the terms and conditions of work doesn't protect the employee from disciplinary action because of the offensive nature of the conduct, the comments. Moving along.
Jeff, we did have a question quickly before you move on. Somebody's wondering if you can touch upon employees' use of social media and free speech or pictures that are a negative reflection on the company. Are employers able to ask employees to refrain from inappropriate postings on their personal social media accounts?
That's a great question. The way what I often look at in the social media policies that I help to develop, usually, begin with, we're not here to police your social media. If it's not a problem, if we don't know about it, it's not our problem. But note that if it's harassing, if it's in any way, offensive, if it breaches those kind of common standards of decency, or if it's targeting another employee, disciplinary action can be taken. Again, if those social media posts are disruptive to the workplace, they can be, addressed. And again, it depends on who the employee is. If it happens to be your CEO, and they are now representing the company, yeah, you can talk to them about look, if you want to be the representative of our company, here's some of the conduct we're expecting from you, and it doesn't involve you with 2 red Solo cups passed out on the couch or whatever the case may be. That is a picture from your college days. And so certainly there is an ability for an employer to restrict that and to request that an employee take something down, or if something really crosses that line, to take disciplinary action. Any other questions for now?
Not at this time. Thank you, Jeff.
Yeah, absolutely. Thanks for the question. So we're going to move over to case law update now. We've had a busy year in the Supreme Court, and Lindsay's going to provide us with some updates on relevant decisions.
Thanks, Jeff, and thanks to everyone for joining us here this morning on this very dreary morning. So in the U.S. Supreme Court, there's been a lot going on that applies to employers, but the biggest one, as we have stated here, the landmark Title VII ruling. And this is the Bostock versus Clayton case. The holding, there's sort of the important point is that sexual orientation and transgender statuses are protected classes under federal employment discrimination laws. So talking about individuals, LGBTQ. All right, so what does that actually mean? Let me break it down just a little bit here. So Title VII, as I'm sure most of you know, has been around since the 60s. And it is a federal law that protects employees from discrimination based on certain classes, one of those classes being because of sex. And when Title VII was enacted, the idea was sex has to do with man versus woman because of the political landscape that was going on and the concern to protect a class that was traditionally considered discriminated against. So, like many things, that has continued to expand on what is the definition of sex. And last year, if you were at our employment seminar, we talked about the fact that there was a circuit split as to whether transgender and sexual orientation would fall under this protection. And the circuit split meaning that the courts right under the US Supreme Court had differing views. Some were saying, no, it's not protected. Others were saying, yes, it is. So it went up to the Supreme Court. And as we probably mentioned last year, we suspected that it would go in the way that it did, which is that Title VII, the because of sex language, does now specifically include, let me back up a second. Title VII as a statute isn't changing, but the interpretation of it, as stated by our highest court, is that sexual orientation and transgender status are now protected. So that that is really a big decision. And while we kind of presume that that's the way things would go, that is now the law. And so it's something to be very cognizant of.
Who authored that opinion?
Oh, great question.
It was a Gorsuch, I think. It was interestingly, it was a Trump appointee who authored the opinion. And I think that that's kind of an interesting note that, you know, you had a Trump appointee joined together with Roberts and the liberals of the court to bring this to where it is. Any takeaways for employers? I mean, what do employers need to be doing now?
Generally, excuse me, there's a couple things. I mean, there's the practical perspective of you need to put aside maybe personal views and realize that it's very important that you're not in any way discriminating based on these broader categories. As far as, you know, maybe some things that you would want to change, perhaps employee handbooks. Some of the handbooks will start out by saying things like, you know, we adhere to the EEOC and these are the classes that are protected. You know, that's not necessarily the most important thing, but just generally being very aware of it and making sure that it is something that is being considered and just being a little more, like I said, cognizant of that in making decisions and making sure that you're not bringing in a personal bias and making some sort of negative decision based on that.
I think it often just comes back to, again, you know, those expectations of performance, those expectations of productivity. And if you have an employee who's meeting those expectations, you know, that should be it. And if you have an employee who's not meeting those expectations, you know, you're addressing it based upon the expectations and not based upon any of these other, you know, protected classifications. And again, the best way to defend against a lawsuit if somebody is saying you considered, whether it's my sexual orientation or my race or national origin, is I have the documentation to show that you are not meeting expectations. And again, we don't like to operate from a place of simply how do you avoid litigation or how do you know this sort of position of, you know, responding out of fear of getting sued. But you know, that's certainly a consideration you would have in the back of your mind as you're implementing these.
Yeah, Jeff, I'm glad you brought that up. That's a really good point. And we always sort of emphasize this in whatever context, that documentation is key. I know sometimes employers just like to sit down and sort of have a casual conversation that doesn't feel like it's a formal disciplinary type action, but it should still be documented because that's the way that you're going to, like Jeff said, defend against the fact that it was a decision based on performance rather than a protected category and an unlawful employment decision.
Lindsay, we did have a question come in from one of our participants. As a faith-based organization, what can we do and cannot do when recruiting and hiring those under protected class of Title VII, gender identity and sexual orientation?
Well, Lindsay, feel free to jump in here, but what Gorsuch said when he authored this opinion was there likely will be opportunities for faith-based organizations to be granted exceptions from this requirement. And he also mentioned the Defending Religious Liberties Act as well. So there are going to be likely going to see some legislation as well. So as a faith-based organization, I think, you know, it's going to be really looking at the nature of, you know, who you are. Some of it may come back to whether you're a for-profit or not-for-profit organization. Some of it may come back to, is this a bona fide requirement of the position to adhere to certain doctrinal values that your faith has? And so it's really going to be on a case-by-case basis, but I don't think that I do think that there are going to be exemptions for faith-based organizations provided.
Yeah, and that sort of helps us segue into the next two Supreme Court cases that I want to talk about, not directly answering the question that was presented, but sort of the idea of how we make sense of religious organizations and their purpose and wanting to adhere to their beliefs in all aspects of the business as compared to federal laws and the attempt to not be discriminating in the workplace. So the next case I wanted to briefly mention, Little Sisters of the Poor versus Pennsylvania and Trump versus Pennsylvania. This was consolidated. I'm sure many of you, if not all of you, will recall the Hobby Lobby case in 2014. And that was a landmark case. It was talking about the specific under the Affordable Care Act, whether the mandate to provide contraceptives as a part of the employer's healthcare plan, whether that violated a business's, religious beliefs, and how the Affordable Care Act interacted with the Religious Freedom Restoration Act, or RFRA. So Hobby Lobby was a big decision saying that there could be this exemption from the mandate for those type of businesses. So fast forward to 2017, an executive order is issued indicating that the categories of employers may actually be a little broader than just a closely held religious corporation such as Hobby Lobby. And the idea was that it could potentially expand to employers just with general religious objections to it, and even more in the sort of quasi-moral ethical. So it was really broadening that. And Pennsylvania challenged this, indicating that the language of the Affordable Care Act did not permit this sort of expansion as to whom could be exempt from it, or what type of employers could be exempt from it. So it actually, even though that is, what is at issue, the Supreme Court in its decision was not saying yes or no as to broadening the scope of the type of employers, or, can it just be people who have more of this moral, ethical opposition to it? What the Supreme Court was deciding is whether the language of the Affordable Care Act permitted the expansion. And so the case got remanded or pushed back to the lower courts. So that is something we're going to see how that plays out, because that was something that came up obviously through Pennsylvania, since Pennsylvania's in the caption of the cases. And it was something that came up from the Third Circuit, which is one that covers Pennsylvania. So we're going to see how, when that goes back to the Third Circuit, how a ruling will be made on that. So it's sort of hard to say what exactly you take away from that, other than there's a lot of discussion about this, and we're going to be seeing a lot more just generally, because in this Supreme Court term, in fact, in the next 6 or 8 weeks, there's a very big case that is going to be argued about the Affordable Care Act generally, and whether the idea that all Americans have to have health insurance, whether that is even constitutional to have that. It's going to be challenging essentially the entire existence of the ACA, of the Affordable Care Act. So that will obviously be a really big thing that we're going to look to. And in some ways, that may somewhat moot the Little Sisters case, depending on if there's a broader decision that the ACA, in fact, is not constitutional. And
there was another interesting Supreme Court case, right?
Yeah. Well, at least interesting to us here as attorneys. As employment attorneys, yes, we love this sort of stuff. And sorry to everybody, we promise we will have a little break here for you to refill your coffee cups and zone back into what we're talking about here, because I do know that this stuff is not nearly as exciting to.
Lindsay,
equally
before we
important.
move on to that next Supreme Court case, we did have a question, kind of a general question about documentation. Must all documentation be signed by employees, or can it be the employer documenting the conversation?
That's a great question. Go ahead, Lindsay.
Oh, yeah, it is a good question. If you're talking about a verbal warning or more of a casual conversation, that's okay for the employer just to have that written down without having the employee sign it. But when we're talking about a formal disciplinary action, that is something that could, lead to sort of, this is your last chance until you're suspended, last chance until you're terminated. Yes, that sort of thing definitely should be signed by the employee. Jeff, is there anything else you wanted to?
Well, I think it's a good idea to have that employee acknowledgement. You're going to have employees who are going to refuse to sign it, and that's you could say that, well, that's insubordination, or you can just put on the paper, employee refused to sign. As long as you have some either witness or somebody, that you can show, look, the employee got the warning, they received this, they were on notice is the most important thing.
So the last case is a consolidated case that has to do with two Catholic schools. So this decision is pretty narrow in terms to who it would apply to. Classic example would be a parochial school. But we want to touch on it just because it's probably something that you've heard of with this. The focus is on what's called the ministerial exception. So there was a prior case where the US Supreme Court talked about a ministerial exception to federal employment discrimination laws, which had a ministerial being defined in the very sort of common sense idea, minister, and that there could be exceptions based on that. What was it issued?
That federal law would not apply to them. And so if you're under the ministerial exception, it's a decision between the church or the faith-based body and its minister. The federal government doesn't get to look over the church to determine whether or not what the church has done is lawful, because the constitutional provision here is a separation of church and state.
Right. So that is something that has been in effect. But these cases were trying to understand exactly what ministerial meant and expanding upon that. And it was in reference to school teachers of Catholic schools. So there, of course, is that religious component to how they're teaching, and the fact that there's going to be religion intertwined in their roles. And this case held that those type of individuals could be considered ministers in the sense of being exempt from the federal laws as to religious discrimination.
Well, employment discrimination generally.
Right. So this, again, it's pretty narrowly tailored to the type of employers, but it's interesting, and it wouldn't be surprising if off in the future we see yet another case that expands upon ministerial exception, just because whenever you have these sorts of terms, it's always subject to challenge. Well, what does that mean, and how do you define that?
So we also saw a lot of activity in the Third Circuit, and particularly there was a couple interesting cases with the Americans with Disability Act. You want to talk a little bit about those? Sure.
These two cases, these are probably a little more practical across the board for employers. So the Americans with Disabilities Act It's similar to Title VII in that it's a federal anti-discrimination law based on an individual with a disability. And disability is very loosely defined. It's not limited to a person in a wheelchair. You know, it can be much simpler, or excuse me, much not as severe. So the first case is Eshelman versus Patrick Industries, and this came out in May. And there's language under the ADA that says a disability that is, quote, transitory and minor is not covered under the ADA. And so this particular employee who brought this lawsuit, he had a lung biopsy procedure. He was off for 2 months for recovery. And then after he came back, he got an infection, had to take a few days off of work. He claimed that when his termination, that because the employer knew that he was covered under the ADA, that it was an unlawful and adverse action to not allow him to be protected under there. And the initial court said, we agree, minor and transitory, it's clear that those things are not covered. Then it was brought up to the Third Circuit, who said, in fact, no, these really are two different things. Transitory is specifically defined as an impairment with an actual or expected duration of 6 months or less. So, you know, basically sort of temporary, whereas minor had never been defined, but the court said that that's not linked to a time period. So in fact, there are distinctions, and there are many cases, such as in this case, where even though it wasn't a, you know, it didn't last for a long time, it was finite in its time period where this individual was considered disabled, or he's saying he should have been disabled, qualified under the ADA, then in fact that was a distinction. And basically the takeaway from this is employers need to be careful not to discount a potential or asserted perceived disability claim simply because the disability was of a short duration. So of course, someone says they have the flu, you know, that's not something that's going to fall under the ADA. But if it's something that, you know, between the flu and someone has a very severe surgery and they're going to be out of work for an extremely long time, you know, some those cases that are in between, to just be a little more careful in assuming that the ADA would not cover those types of employees. And then the other Third Circuit case, pretty straightforward. I'm sure you know that when an individual needs an accommodation, the idea is that there's an interactive process between employer and employee. And just to clarify, this is the Kahani versus Trustees of the University of Pennsylvania. And the idea is, if somebody needs an accommodation, as long as it's not an undue burden for the employer, you have this sort of interactive process. You know, it of course includes medical professionals, but talking about what is it that you need. And in this case, what was requested by the employee was not the accommodation that the employer actually offered. It was a substitute that the employer felt was appropriate. And so the point of this case was that you do not, as an employer, have to give the precise accommodation that an employee is requesting, as long as you're giving a reasonable accommodation, again, assuming that it's not causing undue hardship or expense for the employer. So,
Ian, go ahead.
oh, I'm sorry, I was just going to say what you were, which is Ian's going to talk a little bit here about some important cases that came out of the Pennsylvania Supreme Court as it relates to independent contractors.
Yeah, thanks, Lindsay. And I think you guys can see that there's a theme developing kind of in each of the court systems, and the Pennsylvania Supreme Court is also following that trend, and we have two cases that deal with independent contractors and the unemployment compensation law. And then Lindsay and I will follow up my recitation of these two cases with some practical pointers that employers can implement into their contracts based upon these cases. So independent contractors are seemingly everywhere these days. The new tax law promotes designations of independent contractors. The gig economy is exploding. And then with the pandemic and so many people working from home, a lot of people are opting for independent contractor type relationship with businesses rather than being stuck as an employee with a single business. Why this matters to employers is because independent contractor and the requirements and the differences between independent contractors and employees comes up everywhere. It comes up in the unemployment compensation law, workers' compensation law, taxes, general liability and responsibility, and then Fair Labor Standards Acts and wage and hour laws, both at the federal and state level. So really it all comes down to the classification. How do you tell the difference between an employee and an independent contractor, and how do you designate that? And as designating a person you hire as an employee, then all of those typical taxes and administrative fees and responsibilities come along, where if you designate someone as an independent contractor, you don't have those tax responsibilities. You don't have to administer them as you would a normal employee. So now we know why it's important. Let's take a look at some of the specific cases. First, we have a special touch, which involved a salon. And so you can imagine the type of employees that were hired there. And this has to do with whether Special Touch as a company hired employees and was responsible for unemployment compensation taxes, or whether these individuals were independent contractors and no taxes were due from the employer. Essentially, when the courts are looking in this area, they need to see two things for a person to be considered an independent contractor. First, they have to be free from the direction or control of the hiring party in how they perform the work. Second, the person must be customarily engaged in an independently established trade, occupation, or profession. And the court in this case ruled on what customarily engaged in an independent established trade means. The court essentially found that the person has to actually be involved in the independent trade, occupation, or profession. Before this case, most courts just required that the independent contractor appeared or had the capability of being an independent trade or business. And you can see how that showing would be really easy. I could work for an employer pretty much exclusively, but if I have a couple of business cards and an EIN number and maybe a bank account, well then yeah, I could probably go out and start a business on my own if I really needed to. Here now, the courts are really looking for actual involvement in the independent trade. So yes, those trappings of EIN numbers and bank accounts will be important, but equally important have they provided services to other businesses? Do they have employees? Do they have, multiple trucks or a website where you can buy and sell things? So what would it look like if a person came up to you and said, I would like to be your independent contractor and I own my own business? What would you expect to see if somebody says, I own my own business? Where this can be really actionable is in two places. One is that you'll want to increase your due diligence when you're hiring and investigating independent contractors to ensure that they are actually in business for themselves. And then second, which we'll address with Lindsay in a little bit, is some contractual provisions that you might add to your independent contractor agreements to further protect yourselves, just in case the independent contractor is kind of fudging the idea that they're in business for themselves. The second case, this is less immediately actionable for employers, but it more shows a trend that employers should be looking out for. This is Lohman versus Unemployment Compensation Board of Review. And this is a case that determined the eligibility of a person for unemployment compensation based upon being hired by a company. Here, the court found that Uber drivers were not independent contractors and in fact were employees. And because they are employees, they are entitled to unemployment compensation. Why this isn't actionable immediately for employers is that the case did not also rule that employers must pay employment taxes for those Uber drivers. It was a one-side ruling for eligibility rather than taxes. So this is important because we're likely going to see another case come out of the Pennsylvania Supreme Court and even the federal courts determining whether an unemployment compensation schemes, or maybe just in general, whether these type of gig driver workers and other type of Uber Eats persons are independent contractors or employees. So definitely keep your eye out for that ruling and those fine divisions between determining whether someone's an independent contractor or an employee. So where employers can really put the rubber to the road with these cases is in our independent contracts. And Lindsay and I are going to talk a little bit about that. I'm going to hit two specific provisions. So first, in an independent contract agreement, you usually have a provision called the relationships of the parties. And this is just a bare recitation saying, we are not employee-employer, we are hiring party and independent contractor. Well, because now the courts want to see proof of actual involvement, not just a bare recitation of what you want the relationship to be, now take and expand that provision a little further and write a small narrative about why the independent contractor is actually involved in independent trade or business. State that they have employees. State that they have worked 3 other jobs for 3 other businesses. State that they have bank accounts, EIN numbers. Put in their website. So a third party or a judge, when reviewing this contract, not only understands the intention of the parties, but they see the actual reality of the relationship. And that's really important. Another thing you can do to hold the independent contractor to what they say as being true is put in representations and warranties that make the contractor state, yes, I am in business for myself. Yes, I have employees. Yes, if our relationship ended, I would go on to another independent contract job. So make them represent and warrant that they are in business for themselves. And those two provisions combined will give the employer a little increased protection if they get the wool pulled over their eyes and the independent contractor really is just some guy that looks like he's in it for himself, but he's really just your employee. And so Lindsay's going to talk a little bit about restrictive covenants in contracts.
There was a case that came out just a few months ago, the Telstream case, and it was addressing the fact that in the age of technology, technology moves faster than paper. With restrictive covenants, many of you may have that with certain types of employees. You ask them to enter into an agreement that they will not compete, either while they are employed or subsequent to employment. Especially when they're very specialized and have sort of technical or unique abilities. The gist of the case was that it is important that a restrictive covenant or a non-compete is being addressed in conjunction with the offer of employment. So if the intent of the parties is that the restrictive covenant is part of the terms of employment, then it will be held as valid. So the practical consideration is that if you are making offers to employees and you give them an offer letter with terms and conditions, make sure that if you're asking them to enter into a restrictive covenant or non-compete, that is always in that letter and that it's a part of the conversations that you're having. Because a restrictive covenant is only as good as it is enforceable. So it's a preventative measure so that to the extent the employee is violating that off in the future, that you have grounds to come back and remind them that in fact they are bound to this. And Jeff is going to talk a little further here, I think, about independent contractors, sort of like Ian did, because it has U.S. Department of Labor has recently touched upon the issue as well.
Yeah, the Department of Labor just issued a proposed rule that says, look, an independent contractor versus an employee, the rule is the economic realities. Is the worker in business for themselves and thereby an independent contractor, or is the worker economically dependent on the employer for work, which would make them an employee? So that's basically the gist of it. One of the other things to keep in mind here, as we're moving into the next year, In October of 2021, under PA law, the wage requirement to meet the salary exemption is going to go up to $40,560. Now, keep in mind that goes up another $5,000 in 2022. So we're looking at about a $10,000 increase between now and 2022 as to the salary exemption. So for you as employers, if you have those employees who are in that range, considering what you're going to do with those. And, if you have a small shop of, 5 employees, it's probably going to be a pretty easy decision for you to make one way or the other. Am I going to convert this employee to hourly, or am I going to move them to a higher salary so they can continue with the exemption? But particularly for you folks who have a large workforce, you don't want to start considering this in September of next year. I mean, now is really the time to start looking at this and determining what are we going to be paying in overtime if we move these folks to hourly? What are we looking at? Are we willing to bump up people's salary by $5,000 a year, knowing that, in 2022, it's going to go up another 5. So keeping those things in mind as we're moving forward here. Lindsay and Ian, you guys had updates on medical marijuana, is that right?
Yes. So medical marijuana has been legal in Pennsylvania for many years now. And a couple cases, we've been seeing a trend with lower courts and Pennsylvania courts that are indicating that there is actually a private cause of action. So very similar to the fact that, like we were talking about with disability, if a person feels that they have been discriminated against based on a disability, they may have a cause of action they can bring. Similarly, the Medical Marijuana Act has that very similar language that an employer cannot discharge, threaten, refuse to hire, otherwise discriminate or retaliate against an employee regarding their compensation terms and conditions on the basis of the employee's status as an individual who is certified to use medical marijuana. So this is just a reminder that while right now it's legislation, we're also seeing these Pennsylvania courts saying that in fact there is this cause of action an employee can bring, and it's likely in the near future that this will come up to the Pennsylvania Supreme Court, which would then make it something that is universal as a law to everybody in Pennsylvania employers.
So
Now,
essentially this is saying that the employee can sue an employer if they violate, if they terminate them by way of example because they use medical marijuana. Now, again, that presumes they have the medical marijuana card and they're using it in accordance with how the statute says it can be used. And so that does not mean that you have to allow an employee to get high at work. I think that that's one of the concerns here. And so again, when I look at this, and my advice to employers is you're treating this like you would any other pain medication, Vicodin or opioids that people have a prescription for. They need to be able to be at work and do the work in a manner that is safe, in a manner that's productive. And if you're seeing interference by the use of these substances, you can address that. And caveat again is your federal regulations do still trump state law. So your DOT drivers, by way of example, that medical marijuana card is not going to do them any good.
So something else from the lower court grab bag that we have here that I think might have slipped the radar of some employers, and then also is getting a little traction as to maybe more expansive than initially indicated, is that in Pennsylvania, starting actually back on October 7th, all construction industry employers must use the federal E-Verify program to screen employees before they're onboarded. So to ensure that they're not hiring any unauthorized workers in the United States. Just real quick, you may think you're not in the construction industry, but the law defines the construction industry very broadly, which includes alterations, modification, custom fabrication, building, assembly, site preparation, repair work, or maintenance work done on real property or premises under contract. So in reading in some of the trade publications, there's speculation that even materials providers of construction industry employers might be implicated in this law, depending on how the materials are transmitted to the job site, how much time is spent on the job site. So this is something that if you're, even tangentially related to the construction area as very broadly defined, you should get your eyes on this statute, read it. It's very short and to the point. And then if you're still not sure if it applies to you, contact your attorney and they can give you some insight. And this also applies to staffing agencies of construction industry employers. So it's very broad. It's something that the construction industry needs to be complying with now. And it also opens up these businesses to all sorts of inspections and fines for non-compliance. So it's definitely something to consider if you haven't heard of it.
And that goes to your I-9. That's your I-9 compliance. And so the E-Verify is the federal program to verify that the employee is lawfully allowed to work in the U.S. And that E-Verify program, I've got a number of clients who are utilizing that program, and it's not a big, scary program. It's fairly easy to use once you get set up in it, and it's a fairly easy process to get set up there. So if you have any questions about that, please let us know. I want to just return again to that idea of expectations, and I think Ian wanted to share a little bit about some things he's been reading over about employee downtime and things of that nature, because I do think we're balancing that out. As I mentioned before, a lot of employees are under a lot of stress right now, and a lot of employees are having difficulty managing things. And as we mentioned before, there is leave under the FFCRA for those folks who may need to provide childcare. There are additional provisions that are in the mix here. There's the EAP, considering also, again, that, an employee may be eligible for FMLA if they're suffering from a severe mental health issue. And, this pandemic has brought out, a lot of that for people. So being aware that you're not missing, those ADA accommodations or those FMLA leave requests as needed. But Ian, go ahead and share.
Yeah, so I've been working home for 7 months now. Haven't really been into the office that much. So I've just been, like many of you, personally dealing with working from home and not seeing the colleagues that I enjoy collaborating with. And I realized that, going to work was more than the process of, getting up and having a routine, but it meant a lot more than that. And I think a lot of people are realizing that too. So, but I also realize that, people are getting back to normal, and we need to think about not everything is going to be remote work, but that there's fluctuations here, that maybe we hear about the new normal a lot, and we need to start thinking about making it just the normal instead of qualifying what it is. So when I talked about cybersecurity policies, and Jeff has talked about expectations, again, you need to take a look and see what have you done and where are people at, that are there differences between working from home, working in the office, or are there even differences between people working in the office and how they were able to do their jobs before the pandemic? But you need to take a look at those things and see if we can transition them from temporary changes to something that's permanent. So even temporary changes that may be acceptable now that are to become the permanent changes, we need to make them look like the other rules and policies that we had before the pandemic. So they need to be thought out, they need to be written down, they need to include all your employees and consider all the different issues and unique circumstances your employees have, and transition them from, this is a stopgap measure to help us get through the pandemic's worst times. All right, now we're in the new normal and we're very busy, or we're dealing with lots of furloughs and different things. Well, now, like Jeff said, the state of affairs, the way they are now, could continue for a year, maybe 2 years, especially in how we deal with remote work and allowing employees maybe more flexibility that way. So it's really about bringing parity between the people that work from home and the people that are continuing to stay at the physical office. And one of the things that I've been looking into a lot in the difference in the parity is that I really appreciated, the water cooler talk and just the type of downtime that you would get in the office. Now, we're not talking about naps or, long breaks or anything like that, but just that 1 to 5 minute beat that you would really appreciate to help, clear your mind or coalesce things, or to just, slough off the last project and allow you to ramp up for the next one. And there's actually a lot of interesting research around downtime and breaks and how it benefits employees and employers. There's some countervailing research out there that you lose a couple $100 every year or whatever in lost wages and things like that. But I think the benefits significantly outweigh the detriments of downtime. So just 3 real quick ones. So downtime actually maintains attention. So we have a limited attention span, especially for in-depth, hard analysis and tough work. So when we have those 1 to 5 minutes to catch a beat, it actually allows us to work again for that long span of really in-depth, hard work. There's just a limited reserve of, no break time and doing good, efficient work. Breaks also allow us to retain, process, and connect information. So it's not just about, running through the spreadsheet and getting the numbers down or doing whatever, but it's also about retaining, what are the categories in the spreadsheet, processing, well, what's a better way to organize the spreadsheet, and then 2, connecting, what is the first category and the last category, what do they have in common, and making these connections. So it's that higher level executive thinking that kicks in when you have these breaks instead of just continuing to grind through a project. And then lastly, it allows us to be goal-oriented and forward-thinking. So breaks not only allow us to see the project in a whole, but it allows us to see the project as it's in place in the company or in your daily tasks or in your weekly tasks. So, these are all ways in which, downtime really gives benefits and really increases the productivity and the efficiency of employees rather than, what you would normally cast off as, well, they're really not working for me now, I'm losing money or something like that. So, there's great benefits there.
And if you
Jeff,
see,
do you have any suggestions about how employers can take advantage of those benefits?
I mean, if you see employees who are slacking off, you address it. Again, when I walk through the office sometimes back in the day when I was in the office and I'd see a paralegal on her cell phone, I knew that paralegal was busy and I knew she was churning out work. And so my concern isn't that she's on her cell phone checking her text messages. My concern is the quality of her work. And so long as that quality of work is being met, that's my, the limit of my concern. Mm-hmm. But, if I want to walk past every 5 minutes and see that, employee on their cell phone, then it's time to address it with that employee or address it with a broader policy.
Yeah. And contrary to popular belief on that point is that, surveys consistently show that more people report less downtime than too much downtime. So, we always think that, that people have more time than they need to do things, but it's really consistently across the board that people are clamoring for more structured breaks or that type of water cooler talk than they feel that they have too much of it.
So Jeff,
Yeah.
or Ian, you mentioned, Jeff, you're walking through offices, hallways, you see what people are or aren't doing. What do you suggest for employers when people are working remotely? Like you said, there's the VPN, but how do you think they should monitor that, balancing out, making sure, things are getting done versus, having somebody monitor when did this person log in or out?
Right. I think that comes back to, again, if there's a measurable metric that you can look at to say, what have they produced? That's great. If not, it's regular check-ins with your folks, checking in to see where they're at with the project, getting updates. That may require a little bit more, touching base with more frequency. But I think that really does come back to this, idea of communication, and that, you really are communicating with your employees, and you're really, putting that forth. When we were putting this all together, I was looking for something to go on the invitation, and I came across this picture with the laptop, and it said, "You've got this." And I thought, that's a really great idea. That kind of resonated with me, because of what the time we're in. And I believe that you all have the capacity to get through this, and that you have the capacity to support those people around you. And to be clear, this isn't a one person show. This is about creating a community, and this is and for what we're talking about today is community of work, and to benefit your mission, whatever that mission may be, but you're creating that community. When I was, just a little personal note, when I was 8, my dad died. And my dad was this, he came from this family of Cherokee hillbillies in the Deep South. And he may or may not have been a moonshine runner. He did not go to high school. My mom's from Lancaster County, and she met my dad when she was in Mennonite voluntary service in Florida. And my mom left this school at 8th grade to go work on the family farm. And side note, my mom, 79 years old, just retired as her church's secretary. So my mom's an amazing woman, been super supportive to me. Growing up in Florida, my next door neighbor was a drug dealer. This is in mid 80s in south of Miami. There was an ice cream man who came through our neighborhood, and I wasn't allowed to buy ice cream from his truck because he was dealing drugs from his truck. This is not your typical attorney backstory. But it's not really my story. It's about that community that was around me. It's a story of a family that was supportive. And yeah, I had a drug dealer for a neighbor, but I also had a lot of wonderful neighbors. It's a story about my mom's church who really created a safe place for me, and a nurturing place. And it's about teachers. It's about an attorney. When I was a teenager, I had an attorney. I didn't know any attorneys, and this attorney at my mom's church was my mentor, and showed me what attorneys do. It's about a college professor who encouraged me to go to law school, and my wife, who supported me while I was in law school. Big shout out to my wife. And then it's about Gibble, Crable, and Hess, and this community that we've created, which then really comes back to, it's about you guys, and we're here for you, and we're really thankful that you're here with us this morning, and we're really thankful that you've allowed us to walk with you through these these times, and you've got this, and we'll get through this. And thanks for sharing your morning with us. And we'd really like to, hear from you guys and questions and comments. So we'll be here for a bit. And thanks again.
Thank you so much to all three of you. This was a great presentation. We do have some questions that came in. The first it's going back to the medical marijuana card. If an employee has a medical marijuana card, are they required to let their employer know?
No, they're not. Just as an employee who takes any other type of prescription, you don't want to go around asking employees to list all the prescriptions they're taking. On the other side is, you do, if you notice that somebody is impaired, you can ask them what's going on. If somebody fails a drug screen, certainly, and they produce a medical marijuana card, that's the other component to this. But just as you wouldn't, ask an employee if they're taking a statin for cholesterol or anything else, because those are going to be unlawful inquiries under the ADA, generally speaking, you're not asking an employee whether or not they have a medical marijuana card.
But Jeff, would it be a violation of an employer's policy, or could they have a policy that states that, medical marijuana usage is only permitted if the employee has a medical marijuana card? Would there be some action if it, yeah.
Yeah. Certainly you can require, that if you're using marijuana, you have to have a card. just as we would with any other prescription. So if you're using Vicodin, what we often say in our handbook is you must carry it in the pill bottle or be able to present the pill bottle that has your name and the prescription on it to verify that in fact you lawfully can use this if in fact we find that you're using it.
Yeah, and there are very strict rules in the Medical Marijuana Act on how marijuana must be transported and used for medicine. So you could incorporate those in your policies as well.
Along that same line, does a medical marijuana card allow an employee to use it on the work premises?
No. The act is pretty clear that an employer does not have to allow an employee to use that while at work.
Yeah, so this would be another great example of using the law to guide the policies, the employer policies. So to the extent that the law does not allow certain things, build that into the employer policies so you have recourse against that employee. And very importantly, there's also a variety of exceptions to the Medical Marijuana Act. So for, for federal DOT drivers, for people that are dealing with minors and other certain circumstances of employment would not apply to the Medical Marijuana Act. So look into that as well to make sure that you as an employer don't have to comply with it at all.
Great, thank you. The next question, can you speak to the pros and cons of a compensatory time off policy for full-time exempt employees? Is this something that you would recommend? Any pitfalls that employers need to be aware of?
I think I'm going to need a little bit of clarification on that as far as compensatory time off. Are you referring to the pros and cons of a paid time off? I don't know if you can chat that in quick, or maybe we can move to the next question and then return to that question.
Sure, let's move to the next question and see if I get a response to that. The next question is about remote employees. What are the best practices for supplying equipment to employees that are working both at home and at the office? Do you reimburse equipment at home that they already provide at the office, printers, monitors, etc.? For example, it becomes inefficient to drag monitors and printers back and forth from the office to the home workspace.
That's really up to the employer as to what they want to do there. There's no requirement that an employer provide a home workstation for an employee. And so that's really going to be a question for each employer. You want to provide some amount of uniformity as to what you're doing. And so if you're providing one employee with the double monitors for their home workstation, you need to consider, is it specific to that one employee and their tasks, or is this something that we need to provide to the 9 other employees who are also working from home? But it's really a question for the employer but there's no requirement, but the employer certainly can do that.
Another consideration for that question is if the employer provides everything, they'd have significantly more control over what's being provided, the devices, the software, the hardware. And that could be really important for various times in the life of an employee, say when they're transitioning back to work or when they're transitioning out of employment altogether. If you have employees purchasing, computers and things like that, you have a lot less control over retaining that or getting that stuff back if an employee separates from employment. Another important thing to consider for this is that depending on whether the employee is purchasing these items for convenience or if the employer is requiring the employee to purchase the item, the purchases that the employee makes will go towards their minimum wage requirements and things like that. So if you're requiring employees to buy computers and buy things like that, they still must be earning minimum wage while making those payments. So be careful, especially if you're interacting with your lower wage employees, to make sure you're not running afoul of the Fair Labor Standards laws.
Also, regarding remote employees, we have a question sort of regarding workers' comp. What happens if a person working from home falls on a frayed rug or another dangerous situation that the employer has no control over and that person is then injured? Have we had any cases or any instances like that?
That's a great question. And there's two things I want to bring up with this. And one is, yes, they're going to be covered under your workers' comp because they are working. Just as, you take the construction industry, they're not working in one particular place. They are, always out in the field. And anytime somebody's hurt in the construction industry, there's a workers' comp claim. So it is important to a degree to ensure that employees are working in a safe place. That's really an employee's just, they need to kind of navigate that, but you may want to let employees know, cords and things laying around on the floor can serve as tripping hazards. And, if they trip and fall while they're at work, just as if they were in the office, it's going to be a workers' comp claim. The other thing to keep in mind is if you have employees who are working remotely and they decide, hey, I can do it here in Pennsylvania, but, I'm going to go quarantine with my brother who lives in Maryland. You need to then look at whether or not they are now covered under your workers' comp claim because they have moved to Maryland. And that's going to be, again, case by case situation. We're not talking about somebody who's going, for a weekend visit, but I'm talking about somebody who's physically moving somewhere else, a different state. You have to look at whether or not you're going to need to get an additional workers' comp policy to cover that employee in another state.
And to not harp too much, but I'll harp anyway. To help nip these things in the bud is to plan and have policies in place ahead of time. If it says in the employee handbook that you have to stay in the state of Pennsylvania, then we can head off some of these complicated workers' compensation, unemployment compensation claims based on that. So again, the employer has control and can establish and try to telegraph what they expect. As for working from home, also, OSHA has weighed in on this, and they say that they are not going to lay down any standards for in-home offices or things like that. But if there are complaints or problems, they still do have the right to inspect an in-home office. So OSHA is not completely out of the picture, but it's something that I think could be more dealt up front, like Jeff was saying, with policies, reminders, warnings, and things like that.
Would GKH be willing to provide a sample remote work agreement for employers?
Yeah, sure. Why don't you just email me and be happy to look at that with you.
Great, thank you. Then going back to the compensatory time off question that we had, it would apply to employees who are not eligible for overtime, but would receive comp days in exchange for overtime hours.
Oh, got it. So your comp time. I mean, that is one of the benefits of having a salaried exempt employee. They don't have to record their hours. If they work 80 hours, they get paid as much as if they work 20 hours that week. And you can have a formal policy or you can have an informal policy, depending on the size of your organization and what you need to have in place here. Because it's one thing to say to your team, you guys really knocked it out of the park this week, and you've been putting in a lot of hours. We're going to shut down at noon on Friday just to give you guys a little bit of time off. That's something that an employer can always do. Again, looking at defining who's getting that time off and who fits into that definition is getting treated uniformly. On the other end is you could have a policy that says if you work if you have a set schedule of 40 hours a week and you work over that, you can add those hours to your comp time bank. That gets a little bit, a little difficult to sometimes manage, at least in my experience, because you might have somebody all of a sudden comes back to you and is like, I've got 80 hours of comp time, and that's not exactly the idea for your salary exempt employee. I see it more as an ability for the employer to let an employee take the afternoon off when they've really put in a long week. Or if an employee's coming in on a Saturday to help out with something, you may arrange with them that, you should take off on Monday then.
And we promised we weren't going to talk about the coronavirus or the federal response there too much. But if you're going to change leave or time or compensation before the FFCRA lapses on December 31st, just consider how those changes will interact with your obligations to provide that paid leave and the expanded EFMLA, and just how compensation and timing is calculated.
Yeah, and the FFCRA is expiring December 31st, at least as of now. So probably not going to be a big deal, but it's a good point. If you are looking at making any changes, probably better off to wait until January 1st.
Great, thank you. We then have a question as we head into cold and flu season. How do we handle paid time off when it isn't COVID, or if the employee opts to not be tested, but say they have a fever, they need to stay home? What are the policies there?
We're balancing that out with the FFCRA leave, which provides paid leave under certain circumstances. And one of those, if the employee is under a doctor's order to quarantine or is otherwise waiting for a medical diagnosis. If you have an employee though who is simply saying, I don't have COVID, I'm sick, I'm not interested in getting tested, I'm just going to be out for a couple of days, they can take PTO. But then again, that comes back to the question of, are you allowing that employee to come back into the workplace now because they have, told you that they were symptomatic? And again, symptomatic is, it could be the flu, it could be a cold, it could be allergies, or it could be COVID, but they all kind of have similar symptoms. Are you as an employer going to allow that employee to come back in within a few days of expressing certain symptoms? And you don't have to. I mean, if an employee is expressing symptoms, you can say the requirement is go get a test before you return to work.
Importantly, we have some good resources on this exact subject on our website, gkh.com. And then also, we also want to be considering not discriminating against certain symptoms or certain illnesses. So it has to be a blanket policy that if you take time off for work and then you want to come back, it has to be anyone that had a fever or anyone that had any symptoms, not just, I thought I had COVID, now I want to come back. So if they thought they had the flu and they want to come back, if you want them to test for COVID, it has to be for either if they think they have the flu or if they thought they have COVID. So just a requirement for tests across the board, not picking and choosing when to test and when not to test.
Great, thank you. Could you touch on best practice for when an employer may have to close for a 1 to 2 week period during COVID due to exposure and some staff affected by quarantine and paid through FFCRA, and others who are not exposed, so they're not covered under FFCRA but cannot work due to the temporary closure, but the closure is needed due to not enough staff during that time period? Would the non-covered be eligible for unemployment, or should they pay all for fairness?
That's a great question, and it shows the complexities of each situation and how each situation is going to be somewhat unique and different. Anytime an employee is out of work, as we've seen during this time period, for reasons that are out of their control. So the office is shut down because of we can't run on a skeleton crew here. We're shutting down the office because we have 5 people who are exposed, and we're just going to, call it a week here or 2 weeks. That employee would be eligible for unemployment comp. The employees who are getting the FFCRA leave would not necessarily be eligible for unemployment comp during that time of the paid leave. There's not a double dip into both unemployment and the FFCRA. But so those employees who are either testing positive, waiting for a medical diagnosis, or quarantining under a doctor's order, are eligible for the FFCRA leave. And those employees who maybe are not testing positive but are otherwise furloughed because the office is closed would be eligible for unemployment comp.
Wonderful. That's all we have for questions at this time. We can give it a couple minutes to see if anything else comes in, but otherwise that's all we've got.
Well, if there's no other questions, you feel free to reach out to us. GKH.com is our website. You can find all of our profiles there with our email addresses if you are not regularly in touch with us. And we want to thank you again for being here with us on this dreary, rainy morning, and glad that you could join us. And have a great day. Thanks again.
Thanks, everybody.
Thank you, everyone. Have a great day.